In this Q&A session, I speak with Shaya Lewis-Dermody of the Family Law Project. Shaya started the Family Law Project back in 2012 because she was frustrated at the lack of accessible and affordable family law advice for clients. We share some general information here and both really encourage you to reach out either to Shaya or to one of our other recommended service providers or your own family lawyer for specific advice that addresses your unique circumstances. This Q&A is really general advice only, but it crosses off some of the key questions that I'm asked and that Shaya has asked so that you can make empowered, grounded, objective decisions for yourself. Hi, Shaya. Thank you for joining me for this Q&A session. I guess first, can you just share a little bit about yourself and the Family Law Project for us?
Sure, and thank you, Sallyanne, for having me. So I've been practicing exclusively as a family lawyer for over 20 years now. So I work with clients across Australia with my firm, the Family Law Project. A lot of the work that I personally do is representing children in court, but as a firm, we assist clients through all stages of their separation.
Fantastic. Thank you. Now let's get into the questions.
Yes.
The first one is a really obvious one and basic one, and it is, do I actually have to get divorced? And what are the pros and cons around that decision?
Okay, well, it's actually interesting question and a common question, and a lot of people actually think they have to get divorced, but in actual fact, there's no legal requirement to get divorced unless you're thinking of remarrying. And oftentimes, if you're in the early stages of separation, that might be the sort of last thing on your mind. But there's no legal requirement to unless you want to remarry.
So what are the pros and cons? If I separate and choose not to get divorced, or I do, what are the pros and cons about that decision?
Yeah, sure. And I guess a lot of people make that decision to divorce for their own personal reasons. And you'd work with, in your coaching, a lot of clients of yours wanting that emotional separation from their ex-partner. So that's one of the pros, or can be a pro. One of the big advantages to legally divorcing is it's one step further to ensuring that your property and your financial separation is complete. So that's another advantage of going ahead and getting a divorce.
Yeah. Okay. So further to that, can you explain the difference on that really basic level between divorce and property settlement? Because when we think about it, media, movies, all that, there's a divorce happening, there's a fight happening. It's not actually the divorce. So can you just step us through the difference between divorce and property settlement?
Yeah, and a lot of new clients that I speak with in their booking notes or when they speak to our admin staff before speaking to me will say, I need to speak to a lawyer about my divorce. In actual fact, when I get to the nub of it, it's more around their property settlement. So in family law, you've got your divorce, which is separate to the property settlement, which again is separate to any parenting proceedings if you've got children. So a divorce is simply an order of the court, of the family law courts, that says you're no longer legally married, full stop, that's it. The property settlement, which you can commence at any stage, sooner is usually better, but the property settlement is a formal division of all the assets of the relationship, whether they're in sole names or joint names. It sets out any property that's to be transferred, any cash payments, any super splitting, that sort of thing.
Yeah. And then, of course, we've got the children and parenting separate again. Yeah.
Yes.
It's really interesting to get across to group members or whoever we're talking to here that the divorce is the final part often. Well, yeah, it's that simple finality of dissolving the marriage rather than all of that stuff that comes beforehand, hopefully beforehand.
Yeah, and I mean, one of the reasons the divorce oftentimes comes later is because you're only allowed to apply for a divorce after you've been separated for 12 months. So you can imagine you're not going to usually wait 12 months to start discussing your property settlement or discussing arrangements for children. So often that divorce does come much later.
Yeah. That's great. The next question I was going to ask you is, when can I get divorced, and
Yes.
are there any time limits? So yes, you've got to wait 12 months. What about in terms of property settlement? Are there time limits?
There are. So you can start your property settlement at any stage, but if you decide to get a divorce, or if your ex-spouse applies for the divorce, you've only got 12 months from the divorce order to finalise your property settlement. So it's really important to get your skates on, so to speak, to make sure it's done within that period, because I've seen numerous times clients will come and they've waited, past that 12-month limitation period, and it's really difficult to apply to the court. You need leave or permission from the court to do so, and that can be very expensive, but also there's no guarantee that the court will allow you. Often I've seen it refused.
Yeah.
Yeah.
So you said, get your skates on.
Yes.
What do I need to do if I'm not married anymore, but what do I need to do to get divorced? And do I need a lawyer?
Yeah, so we often assist clients with their property side of things, or to resolve their parenting matters. But when it comes to the divorce, we refer them to do it themselves, DIY, because it is a good way to save in legal fees. It's pretty straightforward. I'm estimating, when you look at the divorce list at court, probably 90% of people are self-represented. The hearings are straightforward. The court's used to people being self-represented for the divorce, and there's kits on their website that you can fill out yourself and apply yourself to do so. So it's pretty straightforward. You can do it yourself or with your ex-partner as a joint application.
And do I have to go to court? You said, the court's used to self-representation.
It depends. Yeah, every matter is a little bit different. It will depend if you've got children. It will depend if it's a sole or a joint application. Yeah. Oftentimes you don't even need to go to court if it's a joint application. If you do have to go to court, it's probably going to be a 5-minute hearing, very straightforward, and a lot is on MS Teams with the court as well at the moment. So very straightforward, yeah.
Yeah, you don't actually have to be physically in the court, which is a gift, I think, that we've been given from COVID. Okay, what about if we're separated but still living together in the same house? Can we still legally get divorced?
Yes, you can. I saw this quite a bit when I was working in Sydney, particularly with the cost of living there, although it's everywhere at the moment.
Yeah. I'm seeing it a lot, actually.
Yeah. So often when people are separating, the cost of setting up a new house is, prohibitive, and people are waiting for their property settlement agreement before they move out. So it happens a lot. You can still apply for the divorce as long as you've been separated for that 12 months. There will be some additional affidavits. An affidavit is kind of, think of it like a statement, a sworn statement. And you and your spouse will need to both do an affidavit, sort of setting out, yes, we're separated but under the same roof. And you'd include things like, we're no longer having sex, we're in separate bedrooms, we do our own cooking, our own groceries, we've separated our finances, our friends and family know that we're separated, we don't socialise, that sort of thing.
Yeah. Okay, what about de facto couples? If a couple isn't married, what do we need to do? What do they need to do?
I guess
then there's no formal divorce because there's no marriage to legally dissolve.
Yeah, and good to know that. I think it's good to know that de facto couples have the same rights and entitlements and obligations as a married couple. So you still have entitlement to a property settlement. You still, if you've got children, you still need to make arrangements for the children. The main difference will be your time limit. So you're not married, so you can't get divorced, but you've got a 2-year limit from the date that you separate to resolve your property settlement. So again, like I was saying a bit earlier, if you wait till after that time limitation, it can be really difficult to get assistance from the court if you need court assistance.
Again, get your skates on.
Yes.
get visibility on your finance and start getting it sorted early. Yes. Let's talk money. Let's continue that down that path. What's it going to cost? I mean, and this question I know is, how long is a piece of string?
Yes.
But it's one that comes up a lot for my clients, even those ones who are thinking, oh, I don't know if I want to stay or want to go. It's going to cost me a lot of money, you know. Give us a little bit about what's it going to cost, Shaya?
It is a hard question, and a lot of lawyers don't like this question. It's going to depend on if you're amicable or not. It's going to depend on whether you need court proceedings. Most of our clients' matters for property and parenting don't need court. And in fact, the court's got rules around you have to try mediation first. So if you can resolve your matter amicably with direct negotiation with your ex-partner, and not go to court and not engage lawyers for a long period, it's going to be significantly cheaper than if your hand is forced or if you decide to go to court, protracted proceedings and so on. So there's a lot of different options to stay out of court. There's direct negotiation, informal negotiation or informal conferences with or without lawyers. There's community-based mediation. There's private mediation. You can instruct a lawyer to write letters or proposals on your behalf all the way through to court. So it really depends on which option is best for you and your family.
Yeah. And again, it's whether an amicable pathway resolution is realistic for you or viable for you. Yeah.
Absolutely. And unfortunately for some clients, it's just not. And for some clients, this is the minority, but for some of the minority, we say, look, there's no point engaging a lawyer to negotiate back and forth. Let's just go to court because it's going to be quicker and have a judicial decision because we cannot negotiate with this other person. It's just not going to happen.
Yeah.
You're wasting your time and money.
It's good to call that early. Like I like that.
I think so.
That you and the family law project are willing to do that rather than engage in a back and forth battle that's just going nowhere.
I think you have to. And sometimes when you're speaking to a client early on, you know, and you can get a sense of the other party and or their solicitor and their negotiation style. And it's just it's not worth spending thousands of dollars on a lawyer assisted mediation, for example, if you know that's just not going to get anywhere.
Yeah. I wanted to touch on something that you shared recently on your social media, and that unbundled fees. Can you explain what unbundled fees are and how it works with?
Yeah. So we do quite a bit of that. And in essence, if you think of it like engaging, if you don't want to have a lawyer or you can't afford to have a lawyer to represent you for everything on an ongoing basis, think of it like dipping in and out of getting legal advice or assistance done. So it might be, for example, we have clients come in for a strategy session with us to get some legal advice and guidance around what their property entitlement might be or what's a reasonable parenting outcome. And then they go off and try and negotiate themselves. It might be someone's in court and they need some documents drawn up. So we just draft the documents for them, but they remain self-represented in court. Another example might be someone comes to us and say, look, we've reached this agreement, or I've got this proposal. Can I instruct you just to write a letter to the other party? So it's just those kind of snippets of advice, and you might come back and forth at different stages that are critical, just to keep you on track, but also to minimise your legal fees.
Yeah, and also minimise your heartache, you know. So
yes.
Yeah, but I like the fact that clients can dip in and out on an as needs basis rather than be fully engaged and just paying.
Yeah. And I think a really good example is someone who might be using a community-based mediation service, and they come to us for advice beforehand. They've got an interim parenting plan. They're going back to mediation in 3 months' time, so they link back in for advice at that time.
Yeah.
And then a month later, they might have an agreement, so they just link back in to get it drawn up, that sort of thing.
Yeah, I love it.
Yeah.
Love it. Okay, still on the money stuff. I wanted
Yes.
to talk about things like superannuation or other assets when it's in a sole name, particularly if the other party won't disclose. What are our options?
Yeah. Okay. So good to know that there is an obligation to disclose. There's a duty of disclosure under the family law rules. I won't go into sections or legislation to bore everyone, but just know that there is that obligation, and the type of things that it's reasonable to request of your ex-partner or for them to request of you are things like bank statements, super statements, ATO statements, valuations of property, pay slips, that sort of thing. Really common to speak to clients who say, I just know he or she is hiding assets, or they're just not giving me their super statements. Super can be fairly easy in that if you know who the super trustee is or the super company, there's a search you can do called a Form 6. And essentially, if you're de facto or married, and what that means is you contact the super company with this Form 6 request, and they're legally required to give you current balances and so on. The other good thing about that is they're not allowed to tell your spouse or your ex-partner that you've made that request. So that's a very inexpensive way to get that information without rocking the boat. Another thing that you could do is you sort of have to weigh up what sort of figures you're thinking, because if you're in court, you can issue subpoenas to banks and other institutions, accountants and so on. But is it worth the expense? Do you go down that rabbit hole? So you really got to make those decisions. You can get forensic analysis of. Often we see a lot of the like sole traders, that sort of thing, hiding, doing the dodgy on the books. That's really frustrating because we can get forensic examination of those businesses, but it's going to cost thousands of dollars. So you just got to decide, do you want to go down that rabbit hole? Do you have the money to spend? Is it worth it? And often it does seem very unfair because it can be easy to sort of hide finances, but there is a duty of disclosure. And if all your property settlement is resolved and you find out at a later date, let's say your ex has like a $50,000 in a bank account, which you weren't aware of, but then you find out later after everything's done and dusted. If you find out about that later, you can reopen the property settlement. The question is, are you ever going to know? That's
yeah. And as you said, how much are you going to spend time, effort,
yes,
energy, and money in finding it? Yeah. And
that's right.
Yeah, particularly in that situation where the other partner, your ex-partner, is self-employed. There's lots of
it's quite common. Yeah.
very legal and legitimate ways of minimizing your income if you're self-employed, but that has
Yes,
implications, through.
that's right.
Yeah. Okay. Another question that I've been asked is, can I ask my spouse, ex-partner, to leave the house? And if they leave, can I change the locks? And this is we're both on the mortgage, we're both on the mortgage, both on the title.
Yeah, yeah.
So can I ask him or her to leave? And if they do leave, can I change the locks?
Yes. Well, you can always ask. I guess the question is, what's the response going to be?
Yeah.
Look, if you're the primary carer of children and that's the family home, it's always, well, not always, generally preferable for children, at least on an interim basis, to remain in the family home. Yeah. The reality is, if both people or both spouses are on the certificate of title, on the title of the property, you both have the entitlement to come and go from the property as you like. I did have an example of this actually when it just comes to mind. I was acting for a wife, and husband had moved out, and 2 months later had said to her, I'm coming back. And she was horrified because you could.
Oh, yep.
And I said, look, I'm really sorry, but you're both on the title. He's entitled to come back and reside in that property until your property settlement has been effected. What we did for her, we wrote to him, kind of an unbundled, like we were talking about before, and said, look, prefer you didn't. Property settlement will work through it, but thankfully he agreed not to move back in just based on that letter. But if your name is on the title, you are entitled to come and go as you like. If there's family violence or an intervention order, AVOs, then, and you're the protected person, get some legal advice, even just from legal aid, because you're probably entitled to stay at the property to the exclusion of your ex-partner. Also, if there's concerns for your safety or for whatever other reason you really want to stay in the property without the ex-partner, you can get an urgent order from the court for what's called sole occupancy. So yeah, if there has been family violence or you're the primary carer and it's not reasonable for the ex to stay there, the court can make those sort of urgent orders. But first is always to try to negotiate yourself if you can.
Okay. I want to move on to parenting.
Yes.
So let's talk that classic 50-50 shared care. What's considered if the parents can't agree? How is it decided? Do the kids have a say? There's a lot in that question. So perhaps we go step by step. The assumption of 50 shared care. Let's talk that one.
It is a myth, and it's a massive misconception. It's gotten worse in the last 15 years or so since the law changed, and there's wording. I'm not going to go into techie details, but it's called equal shared parental responsibility. And essentially, since the law changed and said that, there's even more misconception amongst the community that you're entitled to a shared care type arrangement, the 50-50. It's not the case. I always say what the court would do and give advice to clients around what the court looks at, not because you're necessarily going to court, but it's just good to know what the court would do to use in your negotiation or mediation. So what the law says or what the court would look at is things like how amicable has the separation been or not? Has there been family violence? What's your co-parenting like? So if you've got really different parenting styles, it's probably not going to work. It's going to look at things like geographical distance. So in a city like Sydney, you can imagine if someone lives in the western suburbs and someone else on the North Shore, it's going to be very difficult. What else? Age of children to some extent. That said, you can have a 4-year-old who works very well moving between two houses comfortably. You might have a 10-year-old who's got attachment issues and is highly attached to one parent, and it's not going to be in their best interest to have a shared care type arrangement. It's always going to come back to what is in the best interest of the child or the children. Does that answer the question in a sort of roundabout way?
Yep. There's another, I think, myth or question that I get asked a lot. When do my kids get to have a say?
Oh, yes. So there's different ways. Depends if you're in court or not in court. If you're in court, for example, there's different ways the court will hear children's voices, and they must hear the children's wishes. That's actually one factor that has to be considered. So there's court child experts. Their name changes all the time. That's the current name. They're basically child experts, mental health professionals that work with separated families who do interim reports and meetings with kids and report back to the judge. If you've got protracted court proceedings, there'll be a more extensive family report. In some matters, you'll have an independent children's lawyer, but not all matters. So a lot of the work I do is where I'm appointed by the court to represent children, but they're in matters where it's, high conflict, allegations of family violence, perhaps child abuse, sexual abuse, really welfare concerns, that sort of thing. So there's different mechanisms for the judge to consider children's wishes. If you're not in court, though, then that's a whole different kettle of fish. Is that the expression?
Yes.
I think it is, yeah. I'm known to mixing up my expressions. I put two and merge them together. So if you're not in court, you can go through mediation for child inclusive mediation, and some private mediation services offer that, and also some community-based mediation services offer that as well. And essentially the practitioner meets with the kids separately, and then when the parents come together on a different day for their mediation, the practitioner reports back or feeds back to them what the kids have said and what their wishes are. Ultimately, though, the parents are going to agree on what they want. And if you're in court, children's wishes are only one factor. And so going back to the court, for example, if I'm the children's lawyer and kids have telling me what they want, I need to make an independent assessment as to whether I think that's in their best interest, and it's not always. Unfortunately.
So going on from that, what happens when, let's say we've got interim orders. We've got an informal agreement that the children will move, on a fortnight, week by week basis, or whatever it is. Whatever. We've got an agreement of some sort, but then the children just say, I don't want to go to mum's, or I don't want to go to dad's. What do we do then?
Yeah, so if there's orders in place, you need to show that you're making a reasonable attempt to facilitate the child being handed to the other parent. It has to be encouraging. For example, if you're going to a handover sitting in the car, you can't just sort of sit at the steering wheel not saying anything for the child to get out of the back door. You need to encourage it to happen. If you're not encouraging it, then it may lead the other parent to initiate court proceedings to enforce those orders, which can be costly and stressful for everybody.
Yeah.
What
about, and this is a really tricky one, but what about when, as the parent, you're hearing this from the child, and also you are mindful that what you're hearing is probably not in the best interest of the child? What are the options there? So we've got orders, but the kid doesn't want to go, or the children don't want to go, and also you have reasonable, you have reasonable
concerns.
Thanks. Yeah,
that's right. So if the orders are older, children are obviously reaching an older age. There's no magic number for what age the kids can do what they want. Oftentimes clients think it's 12. I'm not sure why. I think it's because of the care and protection jurisdiction in New South Wales, which is separate. But if you've got, let's say, for example, a 15-year-old and orders were made 5 years ago, that 15-year-old is probably going to do what they want and use their feet, and there's not a lot that the parents can do about it. If you've got fairly recent orders and the kids are still of similar age and you've got concerns for their welfare, then you're either going to have to try or get some legal advice, but you're probably going to have to try to mediate again with your ex-partner to see if any variation can be agreed, or your fallback last resort would be apply to the court to vary the orders, because until those orders are varied, you're technically breaching them.
All right. I didn't preface that I was going to ask this question, but
yes,
I'm pretty sure we'll be okay with it.
We can cut it out if I don't know the answer.
Exactly. child support. So if I'm the primary carer,
Mm-hmm.
and I've always been the primary carer, and perhaps the kids are with me, maybe it's a 10-4, like I've got the kids 10 days a fortnight, their other parent has them 4 days a fortnight. Earning capacity, let's just call it line ball, quite similar. How does that look in terms of child support being paid to me?
Yeah, so child support is going to be different based on your care arrangements, so the 10-4, for example, but also on the salary of each parent, so that the agency can do an assessment for you and let you know, look, based on your particular circumstances of care arrangements and financial capacity, this is what we would assess you as being required to pay or receive. And then you can organise if you do a private collection or register through the agency.
Yep. Okay. Lucky last. Just going on from that, can you explain the difference and also, I guess, the pros and cons of private collection versus agency collection for child support?
Well, I guess, look, a lot of people will do a private collect, and they're usually where things are quite amicable and there's a good co-parenting relationship. The agency collect is really there to ensure that payments made when it's difficult to communicate with the other parents, and also ensure that payment is made in that they actually collect from the employer. So it's taken from, it's garnished from the wages and paid through that way to ensure payment. So yeah, I mean, some people go ahead and get the assessment just to know what the payment would be, but they might then reach a private agreement that says, oh, look, I'm going to pay more, or I'm going to pay less, but I'm going to top up this or that family holiday, that sort of thing.
Yeah.
So it really usually comes down to the level of co-parenting relationship.
Yeah.
Yeah.
Which comes down to how well you can communicate with the other person, really, doesn't it?
Yes, that's right.
Yeah. In finishing, is there anything else that you wanted to share on about your work or just tips and stuff? Again, I've just thrown that one at you without preparation.
No, I don't think so. I mean, we've really just scratched the surface, I guess, in terms of questions, and you can kind of see this these three different areas of the law. There's a divorce, property, and children. I guess I would say always get legal advice, even if it's from legal aid or community legal centre, because it's really arm yourself with knowledge to know what your entitlements might be or what's in the best interest for children, for parenting arrangements. And I think we've sort of covered a broad range of questions there, haven't we?
Yeah, and it is just a surface. It is a scratch of the surface.
Yes.
Group members, I've also, you're listed as one of our preferred providers, so they can reach out to you if they want further advice too. But yeah, very gentle and broad advice.
And what we do is we offer a first free consult for new client inquiries. So you got that half hour of specific advice that's relevant to you and your particular family situation. I think that's key, is to get that real specific information and advice.
Yeah, because as we've mentioned throughout this Q&A chat, it really depends,
Yes.
The answer that you could have given to every one of my questions was, well, it depends. So
yes, without trying to be vague.
okay. Thank you so much, Shaya. It's been really great to chat with you, and I'm sure everybody listening will have gained a bit more clarity around separation, divorce, property settlement, kids. So thanks.